Hey, so in my previous video where I'm talking about writing an email and saying, or writing a letter, email, fax, whatever, to say, hey, do you and your client want to serve each other via email? This guy made this response. He did that and how it saves on process servers and stuff. But in my case, in my personal case, I was dealing with a corrupt, evil attorney who was partly retired, so he would be traveling across America away from his Seattle home. And I'm about 30 minutes from his house, and that's his home office. So what I would do is for a period of time in my case, I didn't accept service via email because it was more convenient for them if they were able to serve via email, because he was traveling half of the year and e-filing, and he'd fly in town if he had a hearing or whatever, where he'd only set hearings if he was in town. So I would drive, if I filed some paperwork, I would drive to his home office and I would leave the paperwork at his doorstep, because Civil Rule 5 says you can serve the other party by delivering it to the attorney's office or leaving it in a conspicuous place. And that's what I would do. And he would have to hire some assistant or neighbor or somebody to pick up the stuff, scan it, and email it to him. And then when they served me, they would have to hire a process server for $100 or more. So in my case, I was willing to drive up the costs. The video that this guy's responding to, so he's talking about how much it saves on process serving. One thing you guys should know is that you need to read the rules for service. Most states it's Civil Rule 5, or just Google Minnesota Civil Rule Service of Pleadings. Michigan Civil Rule Service of Pleading, whatever state you're in. And you don't have to hire a process server to serve every single time. You have to for orders to show cause, like for a contempt hearing or emergency restraining order or the original summons. Those are personal service things in order to appear. That person has a due process right to be personally served, because they could be on vacation, out of town, or whatever. They have a right to be personally served and notified of an action that's its own action in and of itself. A divorce, you have to be served. Any kind of lawsuit, you have to be served personally and handed to. And most states have a rule that you could serve it on the person or somebody that lives there or a child of mature age, as long as you get it to that person's home, to a live human being. But after that, after you open the door to a court case, now contempt and restrainer, those things can happen on their own without an open court case. So they have rules that you have to personally serve somebody, because if your case is dead or closed, you could do a contempt motion. And on contempt, you have to get an order to show cause, or an order to come to court and show cause why you should be found in contempt. Kind of stupid, fancy language. These guys love to make themselves feel smart by saying that. So it should be just order to appear. I think they changed the language in Washington to order to come to court, or order to appear on the language of the forms. But when you're ordered to appear in court or summons to court, you have a due process right to be personally served and notified, because in some places in old Europe, they used to just have hearings without telling somebody. So that became part of due process in America. So we learned a lot of lessons from, even though there's some legal principles like res judicata that came from 400 years ago in Europe. I mean, that res judicata is talking about relitigating stuff over and over. Even though we have some principles from old Europe, we have some other things that were to prevent tyranny, like double jeopardy. You can't prosecute somebody and they're found innocent and then prosecute them again and prosecute them again. And then you're just perpetually holding them in jail while you're trying to get them found guilty. You get one shot at it. So some of those things happened in Europe that were atrocities as far as the justice system, and we fixed them. Now, if we just followed it, it would be great. Let me say one thing about that, about us following. We don't follow the Constitution and the laws a lot of times, and we misinterpret them and misapply them because of our bigotry and bias, particularly against men. And then everybody says, let's go change the laws. The laws are fine. The best interest of the child, when a parent emotionally psychologically abuses a child. The parent's emotional and psychological fitness. Who's performing parenting duties? Who's abusing the child? If there's domestic violence, the home drugs. Those are great laws. That covers everything. It's just when you're proving it in court, you got a biased judge who doesn't believe you or takes her word over yours. That's a corruption with the heart problem, so you need to remove that judge for being incompetent. As long as these fathers' rights groups are sitting there, I want to change the law or change this or change that. You can have great laws. I mean, we have great laws in the books. You can have even greater laws, supposedly. If you have a corrupt judge, he'll do whatever he wants. That's why I protest judges, and I put their address and birthday and driver's license number on stuff, and I'm outing them and letting everybody know who they are and what a corrupt subhuman piece of garbage they are, and that they place a child with a drug addict or a sex offender. The mom has a sex offender boyfriend or something crazy or dangerous. One of my protest signs says a judge said a blind mom who burned the child got a child burned on the stove because the mom was blind and wasn't paying attention to where the kid was. A blind mom who lets a child get burned is better than a seeing dad, a seeing healthy dad. So I do stuff to humiliate them, and you see them starting to change their rulings. But that's kind of an easy fix. Just take time out of your day, hold up a sign, and expose the judge. But my gender's a bunch of punk, sissy little cowards, especially in the father's rights. And when I talk about protesting like that, they're like, oh, that's harsh, that's wrong, that's this and that. So these people are trafficking children and stealing your kids and violating your constitutional right. And you're saying your response is, let's be nice. The founding fathers would brawl with you on the spot for even saying some pussy bitch-made bullcrap like that. Anyway, let's get back to the point. See, I always got a million things going on in my head about things I could talk about. I could do a seminar nonstop, 24 hours straight for 10 days off the cuff without having to like prepare notes or anything like that. Or somebody could throw up a topic and I could talk about it all day. Just like anybody who's experiencing, if you're a mechanic, you've been working on cars your whole life, you could probably sit there and talk about cars all day. It doesn't make me a genius. I just know this stuff because I've been around it and been entrenched in it and been doing it. So back to this. You want to know the rules of service, and you want to know the rules of service and what they specifically say, because after the original summons, the original order to show cause, you can mail stuff, and that's considered service. But most rules in the court say mailing is considered served 3 days after you deposit it in the mail. So if you mail something on Thursday, it lands on Thursday, Friday, Saturday, Sunday. It's not considered served until Monday. If Monday's a holiday, then they were served Tuesday. Now, most of the time, mail gets there the next day. But if somebody mails me something, I'll object to being late and it should be thrown out. And I'll save the envelope, scan it, and then the envelope has a date of when it was deposited in the mail. And then I'll say, they served me this. I was served this mail on Tuesday, and the hearing was Thursday. I didn't have a chance to reply. It's untimely. It should be thrown out. And they're like, I mailed it out the day before it was due. The rules say 3 days later. Are you that, like, attorneys are that stupid? Like, they get away with just mailing stuff, and they're used to people not objecting and the other attorneys not objecting. So when you know the rules, you know how to object to stuff, or you know how to take action. So this guy's mentioning process service. So I want to clarify, people. You can go and, if the other side has an attorney, you can go to the attorney's office and drop stuff off yourself. And then you write up a proof of service that you dropped it off. You just can't personally serve your ex yourself. But if it's not a summons, order to show cause, or restraining order, just about everything else can be mailed as long as you do it ahead of time. And mailing doesn't cost that much. So if it's worth it to me, if I need the convenience of email more than inconveniencing them, I will agree to service via email. In my case, I preferred to make it hard on them to serve me because the mother's attorney was such an evil, sociopathic, woman-abusing, racist prick. He used to force his own women clients to live with him by, tanking cases on purpose. So know the rules and then decide whether you need it for your convenience, or if you don't, maybe you make it harder on them. But I mainly was making that post for a setup if they try and say, oh, he's driving up the cost later on. Well, you got a protection because you said you wanted to save money and to serve via email, and it was your idea. So that's more of a protection for that scenario.